Hi, Tina.
Hello.
Could you tell us why is it so difficult to get justice for conflict-related sexual violence cases?
Well, I think a couple of reasons, but one which has remained a persistent challenge is pre-existing sociocultural norms, practices, and beliefs that are associated with sexual violence. So that in the aftermath of conflict, all victims will face numerous challenges, including potential for reprisals from perpetrators. Possibly they've been displaced, so there's all challenges that are associated with displacement, inability to report, breakdown in law and order, and so on. But when it comes to sexual violence, there's an added layer of challenges. One challenge that victims will often report is that the crime of sexual violence is not considered to be as serious as perhaps killings or torture or other forms of violence, and that's because of prior or pre-existing norms and beliefs in relation to perhaps the place of women in society, who are often the ones who are disproportionately affected by sexual violence, but also on who can be a victim, so that then male victims of sexual violence also encounter that barrier because of notions that are associated with femininity and masculinity. So victims or survivors of sexual violence then get into a space where reporting their abuse becomes a challenge because of that fear of being stigmatized. And when reporting does not happen, that becomes the first challenge to then pursuing any forms of remedies that can support survivors of sexual violence. And also just bearing in mind that justice occurs within an ecosystem. If survivors are able to step out and get access to some form of care, then that level of care can lead to the next and hopefully eventually lead to accountability. So that's on the one hand. But beyond that, there's also the fact that you'll find that states or institutions may oftentimes put in place mechanisms to investigate sexual and gender-based violence. But where these mechanisms fail to take into consideration these pre-existing cultural, sociocultural norms and beliefs, then you'll find that survivors don't come forward. A good case in point, for instance, is the Commission of Inquiry into the Post-Election Violence in Kenya. They were very intentional about getting survivors of sexual violence to give testimony. They hired a gender specialist. They, in fact, did have a chapter in their report eventually on sexual violence. But despite all that effort, only 31 actual victims came forward to testify. And that's compared to the data that eventually came from health facilities that did themselves report to the Commission, that there were in fact 900 plus cases reported to health facilities within 72 hours of the occurrence of the violations. And so you begin to see the disparity, that the cases exist, but due to all of these barriers, fear from survivors, they were unable to come forward. And so in a nutshell, to then support survivors of sexual violence, it becomes very critical to ensure that there's a ready ecosystem to receive them, to give them spaces to come forward, to listen to them in a sensitive manner, and to walk through the journey with them along the way that helps them to seek, pursue, and eventually obtain justice. Yep.
Could you give us some examples where sexual violence cases have been tried, especially conflict-related sexual violence cases have been tried successfully? Could you give us some context where this has been done?
Yes, so one particular case that I have been intimately involved with was a constitutional petition that we filed in Kenya that sought to support survivors of sexual violence that was committed during the 2007 to 2008 post-election violence to obtain justice. Now, this was a varied form of accountability, not the usual criminal accountability type, but one that was seeking to hold the state accountable for its failure to effectively investigate and prosecute the violations that had occurred at the time, but also for its failure to prevent those violations from occurring, its failure to provide emergency healthcare and rehabilitation services to survivors, and its continuing failure to provide reparations to those victims. Now, this case was conceptualized with the idea that given the cyclical nature of election-related violence in Kenya, we needed to find a comprehensive way of speaking to accountability, to then begin to chip away at impunity. So that whereas at the time, because we filed the case in February 2013, there were ongoing processes as a result of the national dialogue process. There was a proposed special tribunal, but by the time we were filing, it had failed to take off. There were cases being pursued at the International Criminal Court, but despite that, there was still a need to pursue complementary mechanisms that would then help us to get a broader scope of justice and accountability. Now, this case was eventually determined more than 7 years later in 2020, December, in the High Court. A landmark decision in many respects, because it was the very first time that these survivors were getting any form of official acknowledgement from the state. But also importantly, the court did determine that the state had failed because of specific cases where police officers were themselves involved in perpetrating the cases of rape against survivors. Unfortunately, though, we've had to go to the Court of Appeal because a number of aspects remain unaddressed and contentious. First being that the court determined that in cases where victims did not report their cases of abuse, then they had no right of remedy. Now, when you're thinking about massive sexual violence, such as occurred in other countries, but particularly the post-election violence, many survivors did not know who committed the crimes. Many survivors did not have the capability of even making it to a health facility, let alone a police station. But again, going back to the instances I spoke about, the fear of stigmatization and ostracization from their communities, and in fact, the state did not put in place any positive mechanisms to give them a safe space to come forward and report. And so we're challenging that to say that the state bears a responsibility, especially in a context where they have what we call in legal terms constructive notice, media reports, the Commission of Inquiry's report, the Truth Commission's report. All of these are speaking to the existence of a multitude of victims. The state then has a responsibility to investigate, but we're also saying that accountability must be looked at not from a contemporary point of view, for instance, as we do with ordinary cases of sexual violence, but they must bear the lens of international crimes, where we're then moving from a direct perpetrator responsibility to command or superior responsibility and beginning to ask the question, who should be held accountable for these failures, or who perhaps may have overseen the commission of these violations. And so we're now proceeding to the Court of Appeal, and we hope for a successful outcome. But I just wanted to mention one other one, which speaks to this ecosystem that I was highlighting earlier. In the Democratic Republic of Congo, there was a case involving a militia group that for religious or on the basis of religious doctrine went into this village known as Kavumu, and for a prolonged period of time, a couple of years, they would go into the villages, abduct very young girls, in some cases as young as 18 months, take them to the bush, rape them, sexually abuse them, and return them to the forest, sometimes found dead. And a number of these cases were reported to the Panzi hospital. And because of the capacity, the forensic documentation that Panzi hospital was conducting, they began to notice a trend. Young girls coming from the same village, the patterns reported are similar. And so they initiated reporting to the police and began to pursue accountability. Unfortunately, the civil system did not take up the case, and eventually, with collaboration amongst numerous actors, including Physicians for Human Rights that I worked with at the time, and trial and many other actors working together with the police and the military courts. They eventually brought a case to the military court. And the interesting thing was the court finding these accused persons accountable for crimes against humanity due to the pattern of the crimes that had occurred, due to the organized nature of the crimes, and all of the elements that were found to have been met in this case. Now, the critical thing to point out is this case shows you what is possible when in fact there is sufficient investment in technical capacity, in collaboration, not just amongst non-state actors, but between state and non-state actors. Also, very critical measures are put in place, such as protection measures for victims and their families, psychosocial support along the way, and so on. So, again, another useful case that could be highlighted. But suffice to say that these are rare, unfortunately, still remain rare success stories, and much more needs to be done.
Would you say that the Kenyan case that you and other NGOs filed, would you say that these cases laid the foundation for the recently filed case by the Office of the Director of Public Prosecutions to prosecute 12 police officers for crimes against humanity in Kenya? Would you say that this laid a foundation for this, and in what way?
I would say yes. I can see quite a direct correlation between steps that were taken by the government, by other actors, following the filing of the Constitutional Petition and the decision itself. Also, just bearing in mind that the Office of the Director of Public Prosecutions, the Office of the Attorney General, are the respondents in the Constitutional Petition. I say yes because prior to this Constitutional Petition, our history as a country was one of impunity where, despite repeated episodes of electoral or political violence, nobody was held accountable. The period following the post-election violence created an atmosphere where we've cultivated public consciousness and acknowledged the need, the impetus to strengthen our institutions, to strengthen our political will so that there can be accountability and fight against impunity for political violence. Now, in this case, one of the critical things that we were asserting, and we continue to assert even in the Court of Appeal, is that the state itself has a positive obligation. It need not wait for hundreds of thousands of survivors to report before it can take action. So it has a responsibility to enhance its capacity, to create specialized mechanisms to investigate and prosecute, and to in fact take action whenever violations occur. 2017, while the 207-208 case was still in court, we had another episode of electoral-related violence. But this time around, the state's action was quite different from what we saw in 2007-2008. First, the ODPP and the police had put in place mechanisms to respond in the event that such cases were reported. Very different from what we had in 2007. Secondly, we then saw a very deliberate effort by the Office of the Director of Public Prosecutions to initiate investigations. And for instance, the Baby Pendo case, as is commonly known as the Baby Pendo case, emerged out of a case in 2017 that involved the shooting of a child, Baby Pendo, by a stray bullet by a police officer who was seeking to push back demonstrators in Kisumu. Out of that inquest and a decision by the magistrates' court that police officers who were superior to the police who shot need to be investigated, the ODPP has now instituted a case that is not only looking at that actual case of police shooting, but is using the lens of crimes against humanity, or international crimes, so to speak, to ask what other violations occurred. And within this now, we've seen charges of sexual violence brought in as well into the Baby Pendo case. And so for sure, I think that the push to really emphasize that the state has a responsibility in the Constitutional Petition, creating the public consciousness on the need for state to take up that responsibility has led to the steps that are now being taken, as we can see with the Baby Pendo case and others. There are also other cases that have been initiated. Yeah.
You have been working in South Sudan. What are some of the transitional justice lessons that you've learned from this context? And are there some lessons that we can transfer to Sudan?
There would be a myriad of lessons, I think. Of course, the context in Sudan is relatively fragile at this point in time. It's difficult to speak to very specific transitional justice mechanisms that would be initiated. The first lesson that becomes extremely critical is the need to have a conducive environment to pursue any form of transitional justice mechanisms. Of course, this is an ongoing conversation in many contexts, but it's extremely critical that there's a cessation of the fighting, that different parties can be brought to the table to dialogue and be able to forge a common future together. And within that common future, hopefully, part of it can be to ensure that we look back to understand the causes of the violence, that we address the consequences of that violence, and we put in place mechanisms to prevent a recurrence of it.
Thank you so much, Christine.
Thank you.